Hi, Ashok. Good evening.
Good evening, ma'am.
Hi. Good to have you here back. So I
Right?
think we can start the session.
Yes, ma'am. We can start the session. Can everybody see the screen in front of them?
Yes, we can. We can see that.
Okay.
Yes.
All right. Perfect. Okay. So, uh, I think so. This is the second of the session. So I don't know how many of the audience today have already participated in the first session. Uh, the theme of today's conversation is going to be to explore through the help of certain examples and certain templates of agreements as to what and the how of actually the monetizing of intellectual property rights, right? And of course, as central to the subject of monetizing IP is the contract, right? And contracts obviously involve a variety of factors to consider, not just IP laws. So what we will be doing today is we are going to be trying to explore some of the overall concepts involved, and not just under IP law, but also under well-established principles of contract law, and then see how we can use that to draft certain example agreements. So they're essentially going to be dealing with three examples today. The first is non-disclosure agreements. The second is technology transfer agreements. And what we will also cover as part of the conversation on technology transfer agreements will be the clauses dealing with licensing and assignment. So if there is no questions at the outset of the conversation, shall I proceed to the first set of slides? So let's take a look at what the basic principles are. Now, what we have to first remember is that insofar as contracts are concerned, first and foremost, they serve the principle and objective of communicating something, right? Now, the moment we understand contract as a document that conveys a story or a document that conveys or is meant to actually send across a message to someone, it immediately tells us that we have to be mindful of one thing and one thing only, which is how will the person who is reading the communication or perceiving the communication be able to understand and appreciate and make sense of what is actually being said within the document itself. Okay. So this is a very, very critical principle to remember, that first and foremost, contract is communication. Now, the second thing that we have to ask ourselves is, what is it that we are trying to communicate through the channels of a contract? Okay. So it's not rocket science. We are, of course, trying to communicate to a reader who the parties to the contract are, what is the background for the parties to enter into the contract, and what is the intention of the parties while entering into this particular contract. Okay, so three main principles to keep in mind. And the intent is always gathered by the words of the contract itself and not by the intent as applied by the parties at the time of the contract being enforced. So essentially, your contract is supposed to convey its message on its own without the aid of any external party supplying the meaning of any clauses. Okay. The next question that arises is, we have talked about contract being communication. We have talked about what it is that the contract communicates. But the question that arises also is, who is the person reading the contract? This is almost the central theme of English contract law, right? Because what English contract law says is that the contract, as understood by a notional third party reader, is the meaning of the contract that will prevail. Okay. So what does this mean? Now let's assume that I enter into a contract with a person B. So he and I will decide upon what is it that qualifies as the terms of the contract. We define our intent in the language of the agreement itself. But the notional third party reader here is a person C who neither of us are able to contemplate or know who it is. Now, if that person C, who has no idea about what is it that B and I have discussed, and what is it that we have understood and agreed upon, if she or he reads the agreement, what is it that they are able to understand as to the transaction between B and I? will determine the meaning of the contract that will eventually hold water in a court of law. Okay. I will pause here for a second. If there's any question on these principles, please ask me right away, because central to the next leg of the conversation will be these principles that we are going to keep in mind. Right? Any questions so far? Okay. Now, this can be very, very challenging. It's very easy to say that we have to keep in mind the third-party reader who we haven't even met or who we don't even know. And we have to think in terms of what she or he will gather from the words of the contract to then decide how our contract is actually worded today, right? Because especially in the context of IP, what often happens is that the two parties to the transaction, let's assume we're dealing with transaction of licensing of a software, software code, or it could be a software services agreement. This is arguably a very technical subject, especially, for example, if the contract is being handed over or contract is being granted to somebody to develop a particular tool or a particular software to achieve a particular utility. Now, it's very common in a situation like this that the two guys get together and say, okay, the scope of the work being awarded is to develop a code, okay, and the code will have to deliver a particular utility. So simple enough from what you have understood so far. But the next question that arises, what is the utility? So it's very common to see that these two characters in the world of technology define the scope of work in such technical jargon that somebody like you and me who have to actually read and understand the contract, if it ever comes before us for enforcement, we will not be able to understand exactly what the scope of work was to later determine whether the work entrusted is actually complete or not. So if, for example, the contract scope of work is defined as development of a tool that will actually end up achieving a particular utility in computer-aided engineering services, resulting in certain automation, checks, balances, avoidance of manual efforts, this by itself will not clarify to any person what actually is being achieved, right? This can be, for example, better drafted by explaining what is the problem that the tool being developed is going to solve. How does it solve the problem better than existing tools? And what is the benchmark for determining what exactly is a successful development of the tool, right? So this will convey to somebody like me who has no background in the field of software as to what exactly is the scope of work entrusted, and therefore understand the IP at the heart of it, as well as the utility that the IP has to actually fulfill. Right? So always bear in mind that from a lawyer's perspective, it becomes very tempting to say that I will leave the scope of work blank and let the technical staff or the actual guys in the field fill up the blank and we sign it as it is. Right? But most people from backgrounds other than law are not experts in communication. So in their minds, if they have understood what they're writing, that is sufficient. But for purposes of contract, that will not be sufficient. Because ultimately, you have to remember that if the agreement ever has to get enforced in a court of law, ultimately the judge who has probably got no background whatsoever in the field of technology, he has to understand what exactly is being written in the contract and then figure out who is right and who is wrong and what should be the relief granted. So never make the mistake of assuming that the moment it starts to feel like a little bit of a subject outside of a lawyer's comfort zone, you just give up and say, okay, this is not my cup of tea. Somebody else can fill up this section of the contract. I will move on. And oftentimes this will mean sitting down with your client, actually subjecting them, for the lack of a better word, to cross-examination. You ask questions, you ask questions, you ask questions until you yourself are in a position to explain in probably simple terms what exactly is it that is being achieved by the two parties to the agreement. And then you ensure that that simplistic understanding that you have is reflected adequately in the agreement, so that tomorrow neither party has to clarify what is being done under the contract and what is the IP at the heart of it. Okay. So next comes the other critical question. We are talking about a notional third-party reader who could, for example, be the judge who has to understand the contract and decide how to enforce it. Now, any judge or arbitrator who has to essentially examine a contract and decide how it is to be enforced will essentially have to look at the contract with a certain perspective. Think of it as a virtual spectacle that the judge is wearing, and the lens through which he or she will read the contract. That is the governing law, right? So to give you an example, I'm going to slightly move outside of the subject of IP here, but let's take an example of a lease operator agreement being executed in the United Arab Emirates. And now here we are dealing with the subject of tenancy under immovable property. Tenancy under Sharia law as well as the local civil code is very different from tenancy under English common law as well as Indian law, right? The Sharia practically defines tenancy as almost a personal relationship between the landlord and tenant, as opposed to a strictly business relationship. Now, if you're going to draft extremely prohibitive or extremely one-sided termination clauses, it may survive under Indian law, but it may not survive under UAE law or under the Sharia. Similarly, IP rights also are defined differently by different jurisdictions. Okay. So China may have a very different approach to how licensing contracts are looked at and reviewed. Indian law could be very different compared to a Chinese law. It could be very different in Singapore. It could be very different in the UK. Another example I can give you is non-compete clauses almost by definition are never enforced under Indian law. But Singapore, for example, stipulates that under very limited and specified circumstances, if the terms of the non-compete are found to be reasonable and balances the interests of the person enforcing the non-compete versus the person who's at the receiving end, then it can potentially be enforced. So the reader's perspective, the notional third-party reader's perspective while reading the agreement, the lens through which he or he will read the agreement, that is the governing law. And while drafting the agreement, you have to be very mindful of how the governing law essentially affects the rights and obligations of the parties that you're defining within the agreement. Now, these 4 points brings us to the next point, which is collateral facts and negotiations. So let me give you a very typical example that we come across.
Ashok, can I just
Sure.
I think there's a question on the chat box where we just clarify Apurva as to what are non-compete agreements.
Perfect. Okay. So a non-compete agreement, as the title kind of indicates, is an agreement not to compete. Now I can explain this in a very simple example. Let's assume that I'm employed with a company today, right? Now the company in its agreement stipulates that while I'm employed with the company, I'm not supposed to work with the company's competitors, nor am I supposed to myself directly compete with the company. That could be option 1. Now, this duty not to either compete directly with the company or to work with the competitor of the company can be further divided into 2 categories. The obligation while I'm still employed with the company, and the obligation not to compete after my employment with the company comes to an end, either because I terminate or the company terminates or the agreement expires. Now, Indian law says that duty not to compete is valid and enforceable during the term of the agreement. But once the agreement has come to an end, you cannot stop a person from competing with the former employer or working with the former employer's competitors, because that will be an unreasonable restraint of trade under Section 27 of the Indian Contract Act. Okay. So this, in a nutshell, is what we refer to when we talk about a non-compete agreement, right, or a non-compete clause. Apurva, does that clarify your question? Okay, almost. All right. I'm happy to take further questions at the end of the session, but the fundamental principle is a non-compete clause is a clause asking somebody not to compete. Okay, so that's a long and short of it. Okay, so we were coming back to the question of the 5th point, collateral facts and negotiations. So going with the very same example of a non-compete clause, it is very common in our experience to come across situations where a non-compete clause is found within the agreement, it's signed between the parties, but the parties have also happily exchanged emails in which it has been assured that this non-compete clause will not be enforced or will not be applicable, right? And it is a standard template, they can't change it, therefore please sign it. But rest assured, this clause within the agreement that you're signing will not make any difference to the transaction. Right? Now, if this agreement is placed before a court for enforcement, if I decide that I'm going to bring that email across and show to the court that, look, this was never part of the agreement that we had entered into, this has just been introduced into the agreement because the party said they can't change the template. It's a big company, they have thousands of employees. It was a standard form agreement. The person from HR said that if I have to change this clause, I have to run it with the legal team. It will take too long. So please sign the agreement and be done with it. Rest assured, we will not enforce it. Now, obviously, the HR probably changes, circumstances change. So now they want to enforce it. So I try to produce this email that says that, look, it was never agreed upon. This was just there. I signed it. Doesn't mean that it was actually part of the agreement. The basic rule of thumb is that once an agreement has been executed between the parties, especially in writing, these kind of collateral facts and negotiations will not be relevant under principles of English and Indian contract law. Only thing that will make a difference is actually the language of the agreement itself, right? In fact, in English law, they go to the extent of saying that the evidence of what is conveyed and exchanged as part of negotiations, it is not even admissible as evidence at the time of enforcement of the contract. So we have to remember that the only thing that will define a dispute between the parties, or the only thing that will define the rights and obligations of the parties, is the language of the agreement itself. Anything else will not aid or assist the parties in understanding or enforcing their respective rights and obligations. Okay. So the task is very simple. You put a contract on paper. That contract on paper should, in its own form, without the need for external aids, convey exactly to the notional third-party reader what exactly is the terms and conditions agreed upon, and what are the implications, if any, on the business transaction between the parties. Okay. Now, this brings us to the next point, the language of the agreement. And though it might seem like I'm trying to preach to the choir by talking to legal professionals about the importance of language, I have almost always noticed that the legal professionals as a community are very convinced that if they have understood what the contract conveys, then it is universally understood by everybody else. That is not always the case. Right? In fact, legal language, going by principles of pure English grammar, can oftentimes offend conventional grammatical senses as well. So when we are drafting agreements, we have to remember two basic concepts while drafting the language itself. One is we need to have clarity of mind. Next, we need to have simplicity of language. And this is something that I conveyed even in the last session, that we have a tendency to employ the language of legislation into the language of contracts, which is a terrible idea. And you can never assume that what is understood when it comes to interpretation of statutes will also be understood when it comes to interpretation of contracts. Interpretation of contracts is an entirely different set of principles. It is governed by an entirely different set of jurisprudence altogether. So never make the mistake, for example, of assuming that if you include the word including in a contract, it carries the same meaning that it carries in a language of a statute. Okay. So always make sure that you're able to draw that boundary, and you have to forget all that you know under interpretation of statutes and then approach the drafting of the contract itself. And therefore, the contract requires an entirely different language investment. So that means that what you're trying to convey should be conveyed with, say, shorter sentences. The use of full stops and commas have to be very clearly marked and identified, and it has to be very precise and accurate. Third, the English language has inherent pitfalls. For example, practice with a C can be construed as a noun, if I'm not mistaken, but practice with an S is a verb. And they can convey two entirely different meanings depending upon what is the context in which you've used it. So when you're putting together the language of the agreement, whether with IP or otherwise, you have to be very, very mindful of the nature of the language you're employing. And as I will convey to the end also, you have to remember that there is almost a law in the subject, which is that there is always a better way to put across a contract. Right? You might think that you have hit your pinnacle as a contract draftsman today, but believe me when I say this, considering the diversity of contracting parties, the diversity of industries, the diversity of people, mindsets, awareness, enlightenment, etc., 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 you will always be challenged to do better, and you can always do better. Okay. Any questions so far? Okay. So, governing law, what is the impact? Right. Now, governing law has quite a bit of impact on the nature of your agreement. Let's assume, for example, we're dealing with IP itself. Okay. And we have a clause which says that IP which I own, I am giving it all to the person with whom I'm entering into the contract. Whether it's license or assignment, that's a more technical question we'll come to later on, right? The simple context is I own IP, let's assume copyright, and I am transferring that copyright to another person by virtue of the contract. Now, one is the economic rights that come with copyright. The other, of course, is the moral right. Now, certain jurisdictions, including English law as well as Indian law, may have restrictions on how you transfer these moral rights. So moral rights, for example, could include the right to be credited as the author of the particular copyrighted work. Okay. So today I enter into an agreement with a producer for giving my novel to be converted into a movie. I still have a right to be credited as the author of the original work. Now, this particular moral rights, I may not always be able to sell depending upon which governing law is actually governing the contract. So if, for example, we are dealing with English law or Indian law, what we typically then do is we say that, look, of course, we want to transfer all the moral rights as well, but in the event the moral right is not transferable due to its inherent legal limitations, then I, as the owner of the moral right, hereby undertake that I waive off my right to enforce it, right? By virtue of the consideration that I'm receiving. So now there is a tweak that we have made to the fundamental scheme of the business transaction. Instead of saying that the right is being sold, we're saying that even if I retain the right, I'm agreeing for a consideration that I will not enforce it. Okay. So now the enforceability of this itself could be questioned because ultimately it's an agreement and restraint of a legal right. But so far, I haven't come across a situation where an agreement waiving off the right to enforce moral rights has specifically been struck down, right? Unless, of course, the consideration is found to be inadequate. The reason why I'm citing this example is that governing law can impact the way in which IP can be monetized and commercialized and economically exploited. So you have to be very clear that before you put together the terms and conditions of the contract, examine the governing law to see whether the business case that the parties have agreed upon is even tenable. Can it actually be recognized and enforced under the relevant governing law? And you can never take this for granted, right? So if today, and I can tell you, there is a massive amount of globalization when it comes to contracting practices. In one of our most recent transactions was an Indian licensee of a technology entering into an agreement with a Singapore reseller of a technology for a technology owned by a Japanese company, right? And you can see 3 different jurisdictions operating simultaneously almost, right? So we had to back check what the position under Japanese law is insofar as IP on the tech is concerned, then examine the Singapore position, then examine the Indian position. Also then ask ourselves very peculiar questions like, for example, is the technology subject matter of export regulations or export control regulations? Can it even be licensed to parties outside of the particular country? Right. And then ultimately we had to figure out which is the governing law that will apply, negotiate with the parties on the application of the governing law, and thereafter ultimately set down what the rights and responsibilities of the parties are. You can almost see that the lawyers of today and the lawyers of tomorrow do not have it within their luxury to say that I can know Indian law and it is sufficient. Today, you're also required to at least tell yourself that, look, these are all the other jurisdictions that could have legal implications. And therefore, if not ourselves being able to examine what the legal position is, we need to at least advise the client to secure adequate opinions from legal professionals in these places. And if we don't make this assessment and we happily stipulate, say, a Japanese law as a governing law, or the Singapore law as a governing law, we are essentially walking into the unknown, right? And walking into the unknown means that the notional third-party reader for whom we are putting together this entire contract we do not know the lens with which he will be viewing the agreement. And if that lens with which he is going to view the agreement prohibits him from seeing certain rights your client has, then essentially the right does not exist for you. So this is a pitfall that you can avoid only by constantly acquainting yourself with developments, not just in your country, but also in jurisdictions across the globe, to at least tell yourself that I have to ask somebody who's an expert in this jurisdiction what their take on the matter is, right? So knowing what you don't know, knowing the, as the very popular say it, knowing the known unknowns is very critical to be able to successfully put together an IP contract when it comes to the transactions of today. Now, obviously, this comes to the next question. The options are restricted by domestic law also sometimes. So I can give you an example. We were doing a joint venture between two parties, one being Indian, the other being Chinese. And the JV was being set up for taking a license of technology and manufacturing the products at the end of that know-how in China, and thereafter exporting it to export markets. Now, one of the peculiar features was that by virtue of this, China being the location of setting up of the joint venture, there were concerns under Chinese law as to what is the kind of IP rights that the Indian licensor is going to have on improvements and modifications. This was a matter of concern. Now, the way to overcome that in our minds was very simple. We will just say that the governing law for the joint venture agreement will be Indian law. And therefore, we will have enforceable rights and obligations, and there ends the matter. But the Chinese law dealing with joint ventures stipulates that a joint venture being set up in China, the agreement can only be governed by Chinese law. Right? So there is the choice of law is no longer left to the parties, or even if the parties agree upon it, it is open for the other party to avoid being bound by the agreed upon governing law simply because they have shelter under their domestic law. So ultimately, the conversations went to such an extent that the entire JV agreement came to be called off, and the location moved to an altogether different jurisdiction. Right? So governing law can sometimes, it's not always up to the parties. Whether or not the parties even have the choice of governing law will have to be examined by virtue of the relevant jurisdictional regulations and laws themselves. And only if the domestic law, the municipal law actually provides for it, then you can even recommend to the parties to decide between themselves which will be the governing law. Right? So even the notion that the parties can decide the governing law cannot be taken for granted. You have to examine that on the strength of every agreement and then take a call, because governing law affects the IP. And if the governing law is restrictive or does not adequately address IP concerns, then you have to change the governing law. But if the jurisdiction does not permit the choice of governing law, then you have to potentially examine the change in jurisdiction, or alternatively advise the client of the risk and let them take the decision as to whether to proceed or not. Now, the other thing to remember is that the governing law also tends to impact the nature of remedies available, the entitlement to those remedies, and the ease with which remedies can be recovered. I'll give you a simple example. Let's assume that your IP licensing contract has a clause that says no matter what, the cumulative liability of the parties under the contract, whether under the contract or whether under tort or whether under law, shall not exceed the sum equivalent to the royalty or the licensing fees, right? It's a capping of liability. So if I am entering into a contract with someone and I say that the licensing fee and the royalty is going to be, say, 200 rupees per month, the limitation of liability clause says that the liability cannot exceed 200 rupees per month. That's the basic principle. Right? Now, there could also be clauses which says that, look, if there is going to be a dispute, right, and I want damages, the moment there is a breach of the agreement, the damages will be 200 rupees per month. Okay, liquidated damages. Now, Indian law has consistently said that you might agree upon a sum of money as liquidated damages, but we will still examine whether or not the losses you have actually incurred is equal to the liquidated damages or not. If it is not equal to the liquidated damages, we will not grant it. If it is equal to the liquidated damages, we are going to grant it. So what you agree upon in the agreement makes no difference to the court of law or to the arbitrator who is applying 73 and 74 of the Contract Act. English law, on the other hand, may take a far more permissive view when it comes to the very same 200 rupees per month claim. So if your client says that, look, I want to recover my liquidated damages without too much of hassle, maybe English law is a better governing law to apply. But if a client says that, look, I would much rather keep my options open and recover losses at actuals, then maybe Indian law is a better choice to apply. So the choice of governing law will also impact the nature of reliefs, right? The other thing, do you have access to equitable reliefs like injunctions, specific performance? Because in IP, more than the damages, what people really want is those injunctive reliefs. You don't want a trade secret to go out in the public domain. And that can only be done through an injunction, because once it goes into the public domain, it's impossible to quantify the losses that you're going to incur by virtue of the trade secret no longer being a trade secret. I mean, imagine a scenario if the recipe for Coca-Cola is actually out in the public domain, right? What does it mean for the valuation of Coke? So that is the reason why in a lot of IP disputes, injunction is what you're looking for. And you have to also ask yourself whether the governing law has sufficient provisions made for these kind of equitable reliefs. And that will then decide whether you want to stipulate the laws of India, the laws of UK, the laws of some other country as the governing law when it comes to deciding on how the contract is to be enforced. Right? Same thing with limitation of liability. If you have a cap on liability, there are judgments of the Indian court that says that, look, how can you restrict a right of relief? If your losses are probably well in excess of the cap on liability, you should be allowed to recover. There are, of course, judgments also that say to the contrary, but you can never take it for granted that you will actually be able to achieve everything you want, especially when it comes to limitation of liability, which say Indian law being the governing law, especially the parties are entering into contract across borders. Right. So especially when it comes to cross-border agreements, don't take the question of governing law for granted. Right. Examine, investigate, research, consult. This is very critical when it comes to ensuring that the contract you're putting together can actually aid the cause of the parties being able to realize their respective rights and obligations. Okay. Any questions so far? Okay. Now, coming to the very specific case at hand, right? Which is IP contracts. Okay. So what we have to first ask ourselves, now we have understood the basic principles of what we need to keep in mind while putting together an agreement. The next question that we have to, of course, ask ourselves is, how do we then take these basic principles applicable to contracts in general, and how do we then apply it to contracts involving IP? Could be a non-disclosure agreement, could be a technology transfer agreement, could be a consulting agreement where the consultant is in India and the client is in the US, right? And then ask ourselves, how do we apply those basic principles to the IP contracts in question? Okay. Now, for that, the first question that we have to ask ourselves is, what is the specific form of intellectual property that we are dealing with? Okay. And believe me when I say this, you can't take what your client says at face value when it comes to understanding the form of IP involved. I'll give you an example. We were recently negotiating an agreement between an Indian entity, a JV entity, or having Indian shareholders as well as Korean shareholders. And the agreement was for transfer of technology from the subsidiary company to the Indian entity. Okay. Now, what made the situation a little more complicated was that the subsidiary company which was transferring the technology was not the owner. They were in turn resellers for their parent company, which was set up in Korea. Now, you can just imagine the number of the layers of parties involved. Korean owner of tech, subsidiary company of the Korean owner of tech in India, which is a subsidiary. Then that subsidiary in turn transferring certain technology to the Indian entity. Okay, so 3 layers. Now, when we initially got down to reviewing the agreement, the clauses were extensively reviewed, negotiated, discussed, and what was pending was the description of the technology in Schedule A to the agreement. It was an appendix to the agreement. So the lawyers did their work. We kind of finally arrived at a language of the agreement that all of us were quite comfortable with. And then we ask the parties to fill in the description of the tech and send it to us so that we can review that as well. And to my surprise and to my amusement, one part of the description of the technology was know-how that taught personnel how to greet customers with a smile. Okay, and I'm not even making this up. This was actually being described as technology within the technology transfer agreement. Okay. So obviously we had some alarm bells going up in our mind, because if what you're transferring to me is the lesson to greet customers with a smile, then there are some fundamental concerns as to whether it is even a protectable form of IP or not. And there is a huge language barrier, right? The counterparts are not fluent in English. We, of course, have language limitations beyond. I personally can't speak anything more than Hindi, Kannada, and English. And we have to now arrive at a definition of technology that's agreeable to both parties, right? And for that, we need to ensure that the IP is properly defined. So during the course of the next 2 to 3 days of trying to examine what actually is the tech and whether it is really just greeting customers with a smile, we realize that there's a certain method by which the Indian entity will be able to optimize a supply chain for a particular product they're dealing with, right? And this is in the form of analysis of data, processing that data using some algorithms, and then coming back with some recommendations to the Indian entity as to how exactly they can ensure that product that they're dealing with reaches from location A to location B in the fastest possible time without any damage, right? So ultimately, we've realized that there's no patent protection for it. It's probably not as abstract as know-how. And then we realized that this is actually IP which has been protected by the Korean owner as a closely guarded trade secret. So the entire scheme of description of the tech vis-a-vis the conversation on IP changed entirely to accommodate trade secret as the frame of reference versus patents. Okay. Now, why is this very important from the point of view of the contract? Right? Because the moment I say that I am the owner of a trade secret and I'm giving it to you as the licensee, I am now informing to the notional third-party reader, as we remember from the basic principles, that tomorrow, if I come back and say that, look, he has actually misused my trade secrets, or he's misappropriating the trade secret, or he's leaking my trade secret, the court knows exactly what is the yardstick by which they will measure my IP. So they will ask me questions like, okay, you are telling me that you have a certain trade secret. What are the steps you have taken to keep it as a trade secret? Have all your employees signed an NDA? Have you made sure that it is not published in any research publications in any management institution? Have you taken adequate measures for data security? Are there, for example, biometric lock facilities? Have you ensured that your employees don't use their personal emails while actually transacting with company documentation, right? Does it have economic value? So I can then ask all these questions as the notional third-party reader and decide whether the contract should be enforced or not. If I don't call it a trade secret and call it, say, I don't know, provisional patents or copyright or something else, the benchmark by which the question of IP protection will be very different, right? So understanding what is the IP at the heart of the monetizing agreement makes it very, very important, because that will then decide the yardstick by which you will be able to either enforce or defend any allegations of breach of contract. Okay. Any questions so far? Okay. Now, going back to the very same example from the Indian entity's point of view, this was hugely beneficial to define it as trade secret, because it was also telling the parties now that, see, this is what is being given to you. Therefore, you now know what are the kind of security measures you need to put in place to protect the IP. So now the Indian entity knows that they have to protect it as a trade secret, ensure their employees are bound by non-disclosure agreements. They need to take steps so that this particular IP is not leaked, right? So it just prevents a lot of confusion between the parties, because if one party is operating on the assumption it is a trade secret, and the other party thinks that greeting customers with a smile is not a trade secret, therefore, why should I protect it? Then chances are that the Indian entity is not taking sufficient measures for protecting the core of the IP, and that results in a dispute. Right? So this clarity of understanding between the parties is very, very important, even as to the identity and the character of the IP in question. And it is up to you as a lawyer to never take your client's description of IP at face value. You probe and you probe and you probe, and then you understand whether or not the IP as understood by your client is actually IP in the eye of law. And thereafter decide what the scheme of the do's and don'ts under the contract is. Okay. So if there are any questions here, please stop me, because I know this is a little bit of a deep subject, and I'm happy to take questions and kind of answer any need for clarifications. Okay. The next question, the context of the parties. So the reason why we have to go into the background of the agreement, the recitals, as you will see, the section that goes whereas, is because it will tell the context of the parties and the reason for them to come together. Now, why this is so important is because if, for example, we are dealing with an employment agreement, right, the background of employment will define a whole bunch of things when it comes to interpreting the rights of the employer and the rights of the employee. It will also then address key questions that will be asked at the time of enforcement regarding questions of undue influence. Is there an inequality of bargaining power? So in order to preempt a lot of these questions that come about regarding the context of the parties, equality of bargaining power, questions of undue influence, coercion, you need to ensure that the context of the parties are properly defined and set forth, right? And the idea being that you want to present as much as possible the fact that the parties have walked into the contract with their eyes open, they have understood and appreciated what they are getting into, and nobody was under any kind of undue influence or compulsions while entering into the contract. Okay. Next, we obviously need to understand the business case, right? So obviously there is a certain commercial objective for the entire transaction in the IP. We need to understand what that business case is. We need to then weigh in with our opinion regarding the business case, and thereafter ensure that the business case that the parties have actually arrived at is adequately reflected in the language of the agreement. Okay. Now, again, never take your client's words at face value, because chances are that your client, being from the world of business or having the business interest in mind, may sometimes propose an extremely one-sided deal as part of the agreement. Now, one-sided deals are, of course, not prohibited by law. It's completely permissible. But especially when you have inequality of bargaining power, you may want to try and see if you can influence a slightly more mutually beneficial deal to be reflected in the agreement for two reasons. One is, tomorrow you are not facing any unnecessary questions of inequality of bargaining power, undue influence, because though you may have a lot of legal remedies left, if the contract does not seem to reflect a fair understanding, you may have challenges when it comes to securing equitable reliefs, like injunctions, like specific relief. So having a fairness in the transaction has some inherent advantages when it comes to enforcement. Okay. Practically, I can recount hundreds of instances when the judge I'm before looks at a contract, and if he finds it to be one-sided, he literally just throws the question as to how do you even expect to enforce this contract? This is so unfair on your part, right? And though we can compel him by law to do it, essentially you have lost the narrative in the first 5 minutes of your attempted enforcement. Now, the second thing to keep in mind is that when you have fairness in the transaction, you also have the benefit of ensuring that tomorrow the parties have no incentive whatsoever to breach the agreement and to actually, just give me 1 second, please. So there is no incentive to the parties to breach. The more unfair the deal is, chances are the parties are going to try and find ways to work around the contract, breach the contract, and avoid the contract, right? So defining a fair business case is almost very critical to ensuring that tomorrow there are no disputes occurring, right? So it's very tempting for a lawyer to say that I'm going to represent the interests of my client alone. In practice, it's a bad idea to tell yourself that, look, I will not even advise the client regarding the fairness or the lack of it in the contract. You counsel your client regarding the fairness of the business case, the sufficiency of consideration, because that could potentially affect the legal risks involved in the enforcement of the contract itself. Okay. So remember, we are officers of the court. Whether we are enrolled with the Bar Association or not, we are officers of the court. We have a duty to be reasonable and fair in our advice. Of course, if after we give our advice, the client tells us that, look, this is the business case I want to propose, we will do what our client tells us to do. But it is our duty to at least inform the client that there is a certain pitfall to a one-sided business case. Right? The next, now we have obviously reflected on the duty of the lawyer to reflect on the fairness of the business case. We also have to reflect on the tenability of the business case. Rights could be numerous, right? But the question is, are those rights recognized or not recognized under law? Are they enforceable under law? Okay. We already discussed the example of moral rights, and a clause that says the moral rights are being transferred whether through assignment or through license. There could be potential questions regarding enforceability, especially in cases of assignment, right? And the workaround also we discussed, which is to give a waiver instead. But let's take another example, non-compete clauses. If today I enter into an agreement with another party, and it says that even after the agreement comes to an end for a period of 1 or 2 years, you will not compete with me or work with my competitor, that kind of a non-compete clause could have definitive questions regarding enforceability due to Section 27 of the Indian Contract Act. Now, you could work around it if you know for a fact that Section 27 could come in the way. So one way of ensuring non-compete is enforceable, you look at the salary that the person is likely to draw for the next 2 years if he was stayed in employment. You look at what he could generate in the market if he were to scout for other jobs and what he could gain as an improvement in the pay package. And then you tell him that, look, I will pay you that money for 2 years not to compete with me. Right. And then if there is an agreement on that basis, maybe it is less non-enforceable as opposed to a plain simpliciter non-compete clause beyond the expiry of the agreement. Right? So again, the keyword here is you need to know the unknowns involved and then see how you can address it. Right? So the other thing to remember, of course, is that non-compete clauses could be enforceable under different jurisdictions. So if it is a cross-border agreement, choose a governing law accordingly. Right? So, but the business case here, which is that I want to protect my interest of my client's business for 2 years after the consultant has resigned, that may not always be tenable under every jurisdiction. And you have to then decide whether the right should even be introduced in the agreement or not. Because if you introduce that right in the agreement and the parties sign it, they are entering into the agreement with a wrong assumption of the requirements of them under the contract. And if there is a wrong assumption in the contract, chances are that there is a potential breach of agreement waiting to happen. Okay. Now, the third thing to keep in mind, the third example I can think of is sometimes it may not be a statute that makes the enforceability suspect in so far as the law is concerned. Sometimes it could be judgments. Okay. Now, I'll give you an example. Google has a system where if I am a brand owner, I can enter into a contract with Google with the objective that if tomorrow somebody searches for my competitor in the Google search engine, in the sponsored search section, my result could come first. Okay, not in the natural search results, the sponsored results. Now, this agreement between me and Google in some jurisdictions is considered a form of passing off and trademark infringement, and therefore may not be permitted. Okay. Now, does the specific law or the statute may call it trademark infringement? It does not. Sometimes it only says that taking unfair advantage of a rival trademark, contrary to honest industrial commercial practices, is for trademark infringement. Right? The statute is abstract, but the judgment is very clear. So when you're looking at the tenability of the business case, you cannot just confine yourself to just the statutory provisions or the rules. You may also have to examine the legal position as laid on by several courts and then decide whether or not the business case is tenable. This was equally true to the case study on the non-compete clauses, because Section 27 only says unreasonable restraint of trade, not permissible, therefore the contract is illegal. But whether or not the post-termination and post-expiry non-compete clause is illegal, that has been defined subsequently by judgments. So having this research done before you put together the agreement is very, very critical. Okay. And last but not the least, when you're drafting a contract for IP purposes, you also have to keep in mind the ease of enforcement. Now, ease of enforcement is achieved through the appropriate choice of governing law in case of cross-border contracts. Otherwise, you also need to keep in mind that when it comes to things like in agreements involving assignment of patents or trademarks or copyright or licensing, the specific law, be it the Copyright Act or the Trademarks Act or the Patents Act, could require you to compulsorily register the agreement with the trademark or the patent office or the copyright office, failing which it may not be enforceable. So if there is a requirement specific to the form of IP, you can refer to the relevant statute, decide whether registration is mandatory, and ensure it is registered. The other common mistake that I see is the failure to pay adequate stamp duty. These days, include the Karnataka Stamp Act and the schedule to the Stamp Act clearly stipulates that there is a stamp duty payable for agreements involving intellectual property. If that stamp duty is not paid, then the agreement ceases to be taken as evidence in a court of law or in a potential arbitration proceeding. So though you have evidence of a contract in the form of the written agreement, you can't present it as evidence in the court. And if it is presented, it could be impounded, penalty could be 10 times the stamp duty payable. So it's a lot of hassles that you would rather avoid, right? So stamp duty, make sure that you examine the question of stamp duty and ensure that your agreement is adequately stamped. Fairness, as we already described, the fairer the contract, easier it is to enforce. Because ultimately, remember, the arbitrator or the judge are human beings. If they find that the contract is fair, they're more motivated to enforce it. If they find that the contract is unfair, rest assured they will try to find as many ways possible to see how the contract can be avoided, right? And there's a saying in the behavioral sciences unit of the FBI. They say that if you look for something hard enough, you will find it, right? So in a lot of these instances, you've actually seen judges come up with very creative reasonings to avoid enforcing an agreement. So fairness is critical to ensure that the question of equity is in your favor at all times, right? And of course, clarity. You want to ensure that the contract is easy, simple to understand, hopefully not very voluminous. If you think the benchmark of a good agreement is a 45-page contract, you're sorely mistaken. The shorter the agreement, easier to read, more precise and accurate the scope of the agreement, and therefore easier to enforce, right? Especially when it comes to things like data collection agreements, where you're giving personal data to somebody. There, the simpler and the easier the contract is to understand, the shorter it is, the better chances you have of enforcing it. Okay. Any questions so far?
Ashok, there is a comment and a question. Would you like to take it now, or should we take it?
Yeah, I'm just going through that. So this is on franchise agreements.
Yeah.
Okay. So franchise agreements are on a slightly different, factual context, for the reason that whenever you are dealing with a franchise agreement, because there is also the franchisee acts as a custodian of the brand, there is also some amount of goodwill that you're putting in the hands of the franchisee, right? Now, the moment goodwill is in the hands of somebody, the courts have not been altogether reluctant to say that even after the agreement has come to an end, in the interest of protecting the goodwill inherent to the business, we can stop people from being in the same field of business for some time. So a good example of this is the Indian Partnership Act, right? Which says that if a partner retires from the partnership, it is permissible to stop him from competing with the partnership business for a reasonable period of time. Even Section 27 of the Indian Contract Act, goodwill is actually a known exception. So when you're drafting the franchise agreement, if the non-compete clause is justified within the language of the non-compete clause by saying that the parties acknowledge that by virtue of the franchise being granted to the franchisee will have access to and benefit from the goodwill of the franchisor. And because he is benefiting significantly from the goodwill and the accrued goodwill that will arise out of the franchise, it is important for the parties and reasonable for the parties to agree upon a non-compete post the expiry. And therefore, the non-compete is as follows. And then you define the territory to which the non-compete is applicable. You define a reasonable term for the non-compete after the expiry. And if you're able to do this entire safeguard, at that point of time, enforceability can become a little easier. And chances are that you might actually be able to even enforce it. Does that answer your question, Drishti? Thank you. Thank you for the question. It's always such a pleasure when the session becomes a little interactive. Okay. Now, the other thing to remember, especially in the context of IP, is that IP always evolves. It never stays in the same form or manner. If we take a look at any technology that we are currently accessing, be it a phone, be it the internet, be it a laptop, we have seen time and again how the way in which the technology started and the way it is today are almost unrecognizable, right? BlackBerry was under the impression that it was going to be market leaders for mobile phones, and today BlackBerry, insofar as cell phones are concerned, is no longer an actor in the market, right? So IP always evolves. And this is also something to remember when it comes to contracts dealing with IP. Let me go back to the example of the technology transfer agreement, right? Now, if I am receiving a tech license from the licensor, I also have some background in the field of technology, right? I'm able to, for example, I might be an expert in textiles, and now I have a tech for a new sewing machine, right? So I'm able to take the license and manufacture the sewing machines and sell it in the country, right? But as I am kind of undertaking the manufacturing activity, I start to notice that there are ways in which the product can be improved upon, right? And I even start to incorporate that improvement. And now the question arises, how do we define the ownership over the modification or the improvement to this particular product or this particular tech that I've received, right? So the agreement is the only channel through which you can avoid any confusion on the ownership over the modification or the improvement, right? So the typical way in which it is done is that in most of these contracts, you have a breakup between two definitions. One is background IP, the other is foreground IP. So background IP is almost always defined as something that I own prior to the execution of this agreement or independent of this agreement. Okay. So, for example, if you're dealing with the same example of a textile industry, suppose I already, even before I came in contact with the licensor, I have my own sewing machine, I have my own understanding of the sewing machine and my own technology around it. That is background IP. Or suppose, without any reference whatsoever to the license that I have received, I develop technology completely independent of the license. That is typically defined as background IP. Now, foreground IP is something that arises in the course of the agreement or pursuant to the agreement. This could, for example, be very specific to the case of I have a license for a sewing machine technology. While working on that, I'm able to now generate some ideas for improvements. That is defined as foreground IP. Now, you will have to then set out in the agreement what happens to the background IP in terms of its ownership and what happens to the foreground IP. So typically, this is done by saving rights of saving pre-existing rights in respect of background IP. And for foreground IP, you stipulate a duty of disclosure. And if the idea is that the foreground IP will also be owned by the licensor or whoever else it is, then you make sure that there is corresponding clauses for transfer of IP rights. Okay. But there's one area which is very tricky, which is derivatives. And I go back to the example of Google and Uber, which I took on the last date, which is two companies working simultaneously on self-driving technology, and engineers from one institute or one organization jumping to the other. Now, when an engineer starts off in, say, one particular company, he's a fresher, he has a lot of theoretical knowledge of engineering, but as he joins the organization, he's given training. And as he is working on the technology itself, he is accumulating experience, which is then able to upskill him considerably, right? He's now a better engineer. He's able to obviously do a lot more than what he was doing before. So he's able to do things faster. He's probably innovating better. Now he is more valuable in the market. So he obviously starts looking for a job, right? So the training that he has received, and while working on the self-driving technology, chances are that he is also exposed to a lot of the confidential information of his existing employer. That has in turn upskilled him. He takes the upskilled version of himself to the competitive business. Right? Now the question arises, how do you segregate the improvement in the skill versus the confidential information which is at the foundation of the improvement in the skill? Has everybody understood the problem statement? I've worked on self-driving technology. I've been exposed to my existing employers, trade secrets, and confidential information. But because I've been exposed and I've worked on it, I am a better engineer. I take the better engineer version of myself to a competitor. And I start working on the rival company's technology in the same domain. Now, the question arises, what do we do when it comes to this particular question as to how much of the work for the competitor is based on the upskillment and how much of that work is a inevitable transfer of confidential information from the former employer to the new employer? Now, this can be very, very tricky. And more often than not, you will see a lot of non-disclosure agreements, for example, making provisions for derivatives, which is not confidential information in its pure form, but things that evolve out of the confidential information. So whether that also belongs to the person who's disclosing the confidential information, or whether the person who's disclosing it has no rights, that is sometimes addressed within the agreement itself, right? This is an inherent challenge. There is no straitjacket formula for addressing this, but it is very important to be able to ask the client with this question, because though as lawyers, sometimes you may not have the solution of addressing derivatives, your client may actually have some ideas on how to address it, right? But again, this is a known unknown that you have to flag off and then get inputs and then address and inbuilt into your agreement. And sometimes you may say it is better to leave it open-ended, right? So that it makes it easier to enforce. But when we were dealing with, for example, the question of patents versus trade secrets, this is the inherent limitation with trade secrets, right? Sometimes derivatives can become very tricky. So you can't tell your engineer not to work with the rival. But if he works for the rival, chances are inevitably, even without him intending to do so, he is disclosing confidential information, right? So being cognizant of these risks will then tell you what is the way in which you'll appropriately address this in your contract, right? One way to do this is also to say that there is a reasonable non-compete clause where you say that, look, you cannot work with a rival without disclosing my confidential information. Therefore, for the limited purposes of protecting my confidential information, even after you quit the company, you can't work with a rival for say 3 months or 6 months or maybe a year. Right? And then the question arises whether it is reasonable or not. Bear in mind, confidentiality clauses have been known to survive the termination or expiry of the agreement under Indian law. Right? It is protected not only under the terms of a contract, but also under the common law of confidence. So sometimes you may try to indirectly enforce a non-compete clause through the question of confidentiality in this manner. Whether it works, doesn't work, that's a case-to-case analysis. But that's one way of trying to circumvent the limitations of non-compete clauses, and also to ensure that derivatives don't end up causing the accidental disclosure of trade secrets. Okay. So any questions so far? Everybody clear with the concept? Okay, so I'm going to quickly run through two templates. I would have ideally wanted to try and build an agreement with all of you, but time is going to be a constraint. So let me see how best I can optimize the time left, right? So let's take the example of a non-disclosure agreement and see how some of these principles can be applied. The context of the parties and the agreement. Now, why is this important? Again, it is to iron out issues regarding undue influence. It is to iron out any potential defenses saying that, look, I entered into the India because I had no other option. And in a lot of instances, when it's the employer enforcing a confidentiality agreement with the employee is known to take the stand that, look, I had no other choice. I didn't know what I was signing. Right? So being able to address the context of the parties and why the agreement is being signed is very important. Now, bear in mind again that we talked about communication to the third parties, but it's also very important that your contract is very clear and legible even to the party signing it. So when you have a situation where it's a big company who's an employer and a fresh engineering graduate who's an employee, how much of your agreement is easily understood and decipherable by the fresh engineering graduate is also very critical to ensure that the agreement is not breached by him. Because sometimes the breach can occur due to plain ignorance, which is no excuse, no doubt, right? You can always say that that can't be a defense in a litigation, but you ideally don't want him breaching the agreement to begin with, right? So being able to define the agreement in such simple language and in a non-threatening and non-intimidating manner can sometimes ensure that the agreement is not breached, right? So what I was saying was that in addition to all the basic principles that we discussed, the agreement also has to be aesthetically pleasing and non-threatening and non-intimidating in its appearance. A 45-page agreement is threatening and intimidating. Chances are the person hasn't even read what he's signing. Then the whole idea of preventing a breach of the agreement is lost, though you may be able to enforce it later. So it's very, very critical that you try and keep the language of your agreements not in very intimidating ways. Try and keep it pleasant, right? And don't always need to conform with the way in which it has been done for the last 60 years. So one example that I constantly give is every agreement has a massive interpretation clause in the beginning, which talks about how references to singular is also reference to the plural. how reference to one gender also includes references to the other. Now, this need not always be in the beginning, because chances are that the person looks at it and thinks that, okay, if this is what is being told to me, I already know this, I don't have to bother. Or he thinks that this is so technical and so couched in legalese, I might as well ignore the contract. Rather, have it at the very end and make a reference to it in the parent agreement, saying this agreement will be governed by the principles set out. The interpretation of the agreement will be governed by the principles set out in Schedule A. Right. So, substance of the contract, the most important clauses which tells the parties what they can and cannot do, make sure that that part is readily readable, comes first, and easily understandable. Right. And is probably in non-threatening language, and try and explain wherever possible why certain do's and don'ts are being prescribed, because then the reasoning or the justification for the do's and don'ts are also within the agreement, right? So nobody can dispute the ethical foundation of the clause itself. Right? So just a quick reference to one additional basic principle which I thought I should mention. Right? So coming back to the NDA, context of the parties needs to be mentioned. The reason why the agreement is being entered into needs to be mentioned. You also need to then define what is confidential information. The purpose being that tomorrow you have to enforce the confidentiality clause. You will have to stipulate with reasonable specificity, which is the law laid down by the California Court of Appeals in Diodes versus Franzen. What is the trade secret and confidential information you're required to, you're actually looking to enforce? Right? To identify the confidential information, the first primary tool you have is a definition of the confidential information within the NDA. Right? And then you, of course, mention the business case. Or that you've already entered into a business arrangement and you want to protect the confidential information. Stipulate the background and foreground IP. This can be done in two ways. One is to mention that the person disclosing confidential information will retain all ownership. By virtue of disclosure, he or she will not transfer the ownership of confidential information to the transferee or the receiving party, and ensure that by virtue of this agreement alone, there is no foreground IP ownership that is granted to the receiving party. And there also address the question of derivatives, right? And to ensure there is ease of enforcement, always ensure that the confidential information definition is easily understandable, that it is fair, and things like the term of the agreement and the term to which the confidentiality obligations survive is defined in reasonable terms. Right? When you do a combination of all of this, you have an NDA that can actually stand the test of enforcement. Okay. The other question, the other template that we can quickly run through is same technology transfer agreements. Mention the context of the parties, again, for the main reason that you want to define it as a principal to principal agreement. That means that there is equality of bargaining power. Then also mention what is the context of entering into the agreement. I have valuable IP. I have spent time, effort, and energy in developing it. Except me, nobody else has exclusive rights over it. Therefore, the licensee actually wants to take a license from me for that particular tech. Right? Define the IP. In technology transfer, it could be a combination. It could be patents. It could be know-how. It could be confidential information. Sit with the client, understand the specific forms of IP involved, make sure that it is adequately reflected in the language of the agreement. Define the business case. So the business case in tech transfer is obviously you want to have a license or an assignment in favor of the licensee or the assignee, depending upon what the parties have agreed upon. You want to ask questions like whether the license or the assignment is exclusive. Exclusive means that only I get to have the license and the assignment, nobody else does, right? So in a way, it ensures that the business case I can generate out of the IP is much more valuable. So for example, it could be defined by way of geography. I could be the exclusive licensee or assignee for India, or I could be the exclusive licensee or assignee for specific states. So the nature of the license or assignment, exclusive, non-exclusive, royalty-free, non-royalty-free, things like that have to be very clearly defined within the agreement. Sometimes the exclusivity could be for specific sectors. You could be allowed to sell to B2B customers, but you don't have exclusivity for B2C customers. So then, of course, the background and foreground IP, which we already discussed. And again, for ease of enforcement, appropriate choice of governing law, fairness in the agreement, making sure that there is an arbitration clause if possible, so that you'll be able to quickly and effectively enforce the contract. Right? I'm really sorry I'm rushing through this because, again, time is of the essence and I want to ensure that I don't overstep my boundaries here. Okay, the last question I want to deal with is the ease of enforcement. Right? Now, dispute resolution clauses can be threefold in nature. You could have a jurisdictional court assuming all control over the enforcement process. You could have a sole arbitrator sitting over it. You can have a three-member arbitral tribunal. Each comes with its pros and cons. And the way you determine which choice you want to take is by asking yourself, how quickly and effectively do you want to acquire interim measures before the arbitration actually starts, right? So that could, for example, decide whether if you're in India and you want to be able to quickly get interim measures, you want to probably then have the Indian courts have jurisdiction, Indian law applicable, and Indian arbitration. If both parties are agreeable, nothing like it. Otherwise, you'll have to negotiate and figure out a via media. The other thing to figure out is the cost. A sole arbitrator could be less expensive versus three arbitrators. So it's very common for me to see a simple non-disclosure agreement between an employer and an employee stipulate a three-member arbitral tribunal to decide on whether the NDA has to be enforced or not. And for such a simple NDA involving employment, a three-member arbitral tribunal can be prohibitively expensive. And there's no reason to actually go into that kind of enforcement mechanisms. So you have to understand the context of each agreement and then decide which of the three options that you want to take. Right? Convenience of the party is very important, especially when I'm dealing with cross-border agreements. Client is in India and somewhere the other party is somewhere else. There's a simple distance-based approach that I take. So if the client is in India and the counterparty is closer on the western side, either Europe or the Middle East or the US, then I try and see if I can stipulate the Dubai International Financial Center courts or the Dubai International Arbitration Center as the forum of dispute resolution. Right? They're effective. They're actually quite cost effective also, and the quality of adjudication is quite good. Right? So convenience is a big part here. It's equidistant for parties on both sides. Sometimes you could also have, say, Singapore International Arbitration Center. And these days, if the arbitration centers are too expensive, you have Singapore International Commercial Court and Dubai International Financial Center Commercial Court as well. And both of them are equally good, if not sometimes better than the arbitration forums that are available, not to mention the fact that they could be more cost effective as well. You also then want to ask yourself arbitrability of the dispute, right? So you have to make these determinations and then decide. Some of the common examples of arbitration forums: London Center for International Arbitration, Dubai International Arbitration Center, Singapore International Arbitration Center, ICC. So you have a variety of factors to consider. Also, be very clear about language of arbitration and the language of the award, because ultimately you need to ensure that you have something easily at hand to enforce in an Indian court if it comes down to it, or in any other court. So making sure that there is a common language agreed upon, especially involving different cultures and different language barriers, will make a lot of difference in terms of protecting the IP. Right? And if you look at examples of KFC is a classic example of a cross-border franchise agreement. Same thing with McDonald's, right? And sometimes there could be serious concerns around quality control and things like that. So having the right enforcement mechanism built into the contract can be very critical. So to conclude, remember, when you're drafting an IP agreement, you're not transcribing. You're not doing the job of being a scribe, and everything that your clients have agreed upon, you end up typing it as it is. You are drafting. Drafting requires an independent application of mind. It requires independent counsel, right? You are being, of course, you will ultimately take care of your client's interests and follow his instructions, but it is duty to counsel and advise, right? Remember, fairness in the contract equals success. It also mitigates legal risks of breach. 3, the value of a contract is defined by a variety of factors, ranging from the fairness of the agreement to the enforcement component, the governing law. So you have to take a very holistic view when you're putting together the contract. And last but not the least, as I was telling you earlier, always remember, there is always a better way to put it across. So if you have drafted an NDA today, don't ever make the mistake of saying, I have drafted an NDA, I can go with the same template tomorrow. Chances are that between today and tomorrow, there's a judgment out there that impacts the enforcement of NDAs. And tomorrow, when you repeat the same template, you have actually ignored that the court judgment. And as a result, your agreement is now carrying an additional legal risk. You could have significant better ways of putting things across. You may learn a new word in the English vocabulary that conveys the same point in a better manner. So remember, there is always a better way to draft your agreement. last but not the least, this is the age of significant innovation when it comes to contracts. What we dealt with predominantly was textual agreements, but today you have visual agreements. You have agreements the future agreements could be a video that is played to both the parties, and both parties video recording their consent for it, right? It could be animation. It could be flow charts and figurines actually depicting what the terms and conditions of the contract are. So this is the age of innovations. And sometimes, for example, I'm so amused when we use a letter format for an agreement instead of the conventional agreement with the buy-in between the recitals and everything. I've had very senior members in very big organizations come back and tell me they do not qualify as a contract. Although the Indian Contract Act is very clear that so long as there's offer, acceptance, and consideration, it is a legally binding agreement. So as a culture, I think India tends to be very averse to innovations in contracts, but the trend is changing. And I think as we go to the future, increasingly the demands will be to draft these kind of future contracts. And we also have to remember that smart contracts based on blockchain is coming out in a big way, right? And how we prepare for all of this is by constantly updating ourselves, both knowledge-wise and in terms of contract practices. And if you're not doing that, then we are falling behind. And remember, foreign law firms are now coming to the country, right? And we don't want them to come and tell a client that, look, Indian lawyers are lagging behind. So it's important to be ahead of the trend and always keep an open mind. And research is not just for a litigation, it is also for a contract, right? So with that statement, I come to the end of the session. Thank you very much. Any questions, please feel free to shoot.
Any questions from the participants? Looks like there are none. Just that Drishti has a question, where can we download this video? Drishti, the videos, the links to the video would be sent to you by email, would be sent to the participants by email. So you can take a look at the videos and go through them once again. So thank you, Ashok. Thank you very much for a very, very informative, very clear and comprehensive 2-day preview session that we have had in terms of the commercialization of patents. So that's a very important subject in terms of intellectual property, where it's not just about identifying the intellectual property, but also in terms of going about with commercially exploiting it and making the best use of the exclusive rights. What was very interesting in today's conversation, in today's discussion, was it all started with the basic principles of the contracts, of the general principles of contracts, going further to understanding the governing law in the context of intellectual property rights enforcement. And a very important point that Ashok kept repeating was knowing the known unknown. That was a very important phrase, especially while you come up with your drafting of these contracts. These are something which are very, very important. And we also had a very good understanding of the position of law, especially when it comes to cross-border licenses and to consider export-import licenses and various other factors, the different parameters that we will have to consider while actually defining these contracts. At the same time, keeping them simple and as you very rightly put it, clarity of mind and simplicity of the language, which is very, very critical. Also, thanks for bringing about the two important, it was more like a workshop mode where you brought about the key points while a lawyer would have to consider drafting an NDA or a technology transfer agreement, which was very, very useful through the session. And also the contemporary forms that were brought about, where, in terms of visualization, smart contracts, and various other things, which are also going to be the order of the day. So thank you for bringing out all of these. And with this, we come to the end of the preview course on intellectual property rights. The assignments would be, they must have already been sent out to you, because we have some of the participants who have already finished the first assignment and they are now yet to go to the second one. However, the assignments will follow through the session. You'll be provided with the assignments. Please do work on the assignments and submit them to us. And this is pretty much the format that we will be formatting. Okay, I'll just check that out, Apurva, and yes, you would also get it on the email. Yes, we will ensure that the participants would get the assignments on the email as well. And this is pretty much the format that we would be following through the 1-year program on advanced intellectual property rights, where we are going to have totally a sort of a practical, conceptual as well as a practical exposure to the subject of intellectual property, where you would actually be sort of industry ready by the time you move out of the advanced learning program, and you would sort of be prepared to get into an IP law practice, which is one of the most sought after careers in the present times. Thank you all. Thank you so much for being a part of the 2-day session. And please work on the assignments and come back to us. Do take up the course. Please do go through the website as well. Get to know more about the course and do enroll with the course. And look forward to seeing you all at the advanced upskill program of intellectual property rights that's conducted by EBC Learning and CII. Thank you so much and have a good evening. Thank you, Ashok.
Thank you, ma'am. Thank you so much. My pleasure.
Bye.